Shh. You are Frankie Farias. Mr. Farias, you're charged with two cases. You're charged with driving while intoxicated. You're also charged with assault of a family member. You're facing up to a year on the assault case and or a $4,000 fine. And on the DWI, you're facing up to 6 months in jail and or a $2,000 fine. What have you guys worked out?
So for he's pleading time served on the DWI, 13 months deferred on the assault conditions.
Okay. This is how you understand this agreement.
I'm sorry.
You have two agreements on both of your cases. On the DWI, they've offered you 3 days in jail.
Pause here. This is the judge giving the lifelong consequence warning. When they say it'll stay on your record forever, that's not exaggeration, it's the legal truth. In the US, a DWI follows you like a neon sign for every future police encounter. Even one drink behind the wheel after this, you're stepping straight into a legal nightmare.
It is that you've done, but you need to understand that that charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. So this time served, it's a minimum of 30 days in jail. Anytime you get pulled over, an officer's going to look at your record. They're going to see this. What do you think they're going to do if you smell like alcohol or dope? Right. I would never, even if you've had a sip of alcohol, I would not get into a car because it is a humongous risk. As far as the assault of a family member is concerned, you've worked out an agreement. They're offering you a 13-month deferred. Deferred is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. You must understand, though, that this comes with an affirmative finding of family violence, meaning that if you ever pick up another one of these cases, even if you successfully complete the deferred, you will be looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can also never own a gun or ammunition as well. You will be signing this other piece of paper here, which is a written admonition that you are ineligible to possess a firearm or ammunition as a result of this plea bargain agreement as well. What you need to understand, it's firearm is a very loose term. So you need to understand, if you don't understand what a firearm is or what a weapon is, you need to talk to a lawyer because that's one of the conditions. Do you understand? When you pick up criminal cases, there are a lot of collateral consequences, as you now see. It can impact you in ways that you never, ever see. That's why you need to strive to never pick up any kind of cases. And when you pick up multiple successive cases, it kills you. And now you're ending up with these things, with both of these. Anytime you come into a contact with an officer and they look at your record, you think that you'll get the benefit of the doubt. Be careful. Just, that's all I'm going to tell you is be careful. Now, part of the agreement on the deferred, you need to also understand you give up nearly every right known to man by entering this agreement. If you fail to live up to the terms of this agreement, we will issue a warrant for your arrest, put you in jail, and now you're looking at an entire year that you authorize to put you in custody if you violate this. Do you understand? For you to complete this successfully, you have to do a Batters Intervention Prevention Program, what's called a BIP class. This is a 15-week, I'm sorry, is it it's 18, right? 18-week class that you have to go to one time a week for 8. You don't have to do this. We can set your cases for trial if you don't want to do this. Well, look, if you have that kind of attitude and you go into it.
Attitude, Judge, is just, I mean, I understand, I messed up. I messed up. It's no one's fault but mine. I understand that, but y'all really treated me like I'm constantly getting in trouble for it. I'm not. I mean, I understand. I got a DUI and I ended up catching another.
Criminal court. Did you think this was going to be rainbows and
No, I didn't think that. I'm just, it's just,
And here's the thing though, Mr. Faris, what you need to understand is if you think it was bad here, that's what you're saying to me now. If you think it's bad now, wait till you get out there in the free world with even more conviction on your record. Life will only get more difficult with the more convictions that you get.
I hadn't been getting in trouble for the past year. I got that DUI in 2020. I have not been in trouble for it since then. So y'all treating me like if I'm constantly getting in trouble for it. And I'm not trying to be rude. I'm really not.
How did we treat you that you're constantly in trouble? Tell me.
This is a conversation.
It's no, but Nathan, I want him. How did we treat you in what way?
I mean, I'm not
Tell
saying
me.
y'all treating me in any way. It's just like the way you talk to me. I have like I'm just a hardened criminal. All I did was I was young. I made a mistake. I was 20. I made a mistake. I was drinking. It was just a mistake.
Please do not admit to committing the offenses. We actually haven't been found guilty yet.
You mean how I'm talking to you right now?
Yes, sir.
I'm telling you what to expect.
And I understand that,
And I'm
but
telling you how it's going to affect you.
and I understand that.
And I'm telling you that you can't own a gun.
That's fine. No problem.
You can't own any ammunition.
That is fine. No problem whatsoever.
If you pick up another assault like this, you're looking at 2 to 10 in the penitentiary.
See, but I didn't assault nobody. But I
You're pleading
understand.
guilty to assaulting.
But I understand.
You're-
I'm not going to take your agreement. If you're telling me you're not guilty, then we're not going to do it.
That's how this works. You're pleading guilty and admitting that you committed a crime.
Okay.
If you stand up here and say that you didn't commit a crime,
No,
then
no,
you're not pleading
this
guilty.
isn't like, I don't, it's not a game. And I'm not going to let you
Understand that.
plead guilty if you're not guilty. If you're not guilty, then let's try it. I'm not taking your plea of guilty if you're not guilty. That's it. You know,
At this point, I politely request that we reset this case, short distance, have the client's appearance be required.
well, hold on a second. How old is the case? I mean, the case is from 20, it's 510 days old. No, we set the case for trial today.
We'll do that.
That's it. And here to play games. If you're either guilty or you're not guilty, but we don't plead people guilty when they're not guilty. That's not a game that we play here. And understand the way I talk to you now is in hopes that you don't pick anything up in the future.
I
Because
promise you I haven't.
do you know how many times I hear that?
I'm pretty sure you hear it on an everyday basis. I'm
Every
sure you do.
Same.
But I am one of those persons that means it when he says it.
I'm going to hit the pause button.
You
This-
pick up a case in 2020, and now you pick up a case in 2023.
I'm going to hit the pause button here. What you're getting upset about is actually the language that the judge is required to say. He's not admonishing you about anything special about your case. He doesn't care anything about you. But what you're pleading guilty to
No,
carries
you're-
with it these consequences.
I understand.
If you plead guilty to an assault family violence, there's an affirmative finding of family violence, as was explained to you. A second offense is automatically a third-degree felony. Third-degree felony punishment range is 2 to 10. If it's a strangulation, it's now 2 to 20 because it's a second-degree felony. This is automatic, has nothing to do with you, only has to do with what you're pleading guilty to. The DWI is similar in concept. If you plead guilty to DWI today and get convicted, which is what you're planning on doing, the second one is automatically a Class A misdemeanor with a maximum punishment of a year in county or a $4,000 fine. That has nothing to do with the facts of your case and your level of guilt. It's just the fact that you are pleading guilty. At the same time, I don't like this conversation. We're walking away, and we're going to have a later court date. So you go over here.
So if you want to continue on the DWI and tee up the assault, we can do that as well.
No, Judge. With him, we're not doing any pleas. At your request, we'll set the case for trial. I'd ask for 30 days. I'll have a conversation with
Totally.
him. And if he wants to do the plea, we can do the plea. And he will come up here with the proper understanding.
It's not a big deal, but we either set it today or we.
Oh,
Yeah,
I'll just set
okay.
it today because it'll be long enough that we can have a conversation. Almost
So-
30 or so days, Judge.
Yeah, November 19th. That's,
That's fine.
it's over 30 days.
Yeah.
Okay.
It's not that. It's just that I don't remember when Thanksgiving is. Which is a week or two after that. So we're fine.
It's that Tuesday. So it's the Tuesday before.
Tuesday, the week before.
Correct.
We're fine.
Okay, 11/19 it is on both cases.
Is Ramona in the back? Do I need to go talk to her?
Yes, no. Well, I'll tell them. But don't let
No,
him leave.
Nathan, you're fine. It's a good day.
Ramona.
You're welcome.
Who said my name?
Yeah. This is Mr. Wiley, another plea, Your Honor.
It's not a big deal. Good morning, Mr. Wiley.
Good morning, sir.
Mr. Wiley, you're charged with failure to identify oneself to a peace officer while being a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in Harris County Jail. How much credit does he have?
71 days.
71 days credit that you already have. You're giving up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. It will go on your record and you can't take it off. Is this what you want to do?
Yes, sir.
You need to also understand, Mr. Wiles, that from now on, you will be facing a minimum of 90 days in jail for any cases that you pick up. Do you understand?
Dealing with the same exact.
If you pick up cases in the future, it's a minimum of 90 days in jail. Is this what you want to do? How do you plead to the offense, sir? I will find you guilty, sentence you to 3 days in jail, give you credit for the 71 days you've done. I will roll your call costs, you won't owe anything, and good luck to you, sir. Thanks. Thanks, sir. Good morning, ma'am. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On September 8th, 2024, an officer was dispatched to a target in Harris County, Texas regarding a theft. Upon arrival, the officer met with the complainant, the loss prevention manager, who advised the defendant had stolen from the business. The complainant advised that the defendant had entered the business with no merchandise and with a small pink fanny pack on her person. The defendant was then observed going to the style department and began making selections at the merchandise and then began going into the business fitting room. The defendant exited the fitting room and the style merchandise was not seen, and the defendant dumped the merchandise on the rack in the fitting room. The defendant was then observed going to the jewelry department, and the complainant advised the defendant was observed quickly selecting Kendra Scott jewelry, and the defendant went to the beauty department and was advised that she began selecting Kendra Scott jewelry and hair care department merchandise. And the defendant then went to the home department and then the chemical aisle and began concealing merchandise into the small pink fanny pack and began walking towards the front of the store. The defendant passed all points of sale without rendering payment for the items, and the total amount taken was was $103.92.
And where did you say this is from?
At Target.
Got it. Okay. Ms. De La Cruz, I'm going to find that there's probable cause to go forward with your case. How old are you, ma'am?
19.
What do you do for a living?
I go to school,
Where do you go to school?
Pima Medical Institute.
Okay. Are you working as well?
Not currently.
Who do you live with?
My parents.
Are they here today with you? Okay. Like I said, I'm going to find probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Target stores whatsoever. You were given a free bond, so we let you out of jail. And that's how you're here before me. You're not going to get another one. If you pick up a new case, if you go to any Target or do something you're not supposed to, I will revoke the bond, put you in jail. You will not get any more PR bonds, and it's going to go way higher than it is now. Do you understand?
Yes, sir.
Did you want to apply for a court-appointed lawyer, man? Okay, we will give you an application. I'm going to have you go to Victoria, sign a reset. After that, we'll have you take a seat in the jury box. Do not leave until you sign our bond conditions up, okay?
Where do I go for it?
First, we're going to have you sign a reset, and then we need to give you an application for an appointed lawyer. I need to know everything about you, and then we'll have you take a seat in the jury box. Please. Good morning, Mr. Javed.
Good morning.
Sir, you're charged with terroristic threat or a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 8th, 2024, in Harris County, Texas, an officer was dispatched to meet with a firefighter at 3515, a residence in Harris County, Texas. The officer met with the complainant, who stated she got into an argument with her husband, the defendant. The complainant stated the defendant had been threatening to kill the complainant's family in Pakistan and to kill her in the past. In 2023, she called the police, but no report was made because she was afraid of retaliation. The complainant stated they have talked about who the defendant knows in Pakistan and believe the defendant could do something to her family to have them killed. The complainant stated the defendant made these threats to her and her family to control her. When the complainant called for police on October 8th, the defendant told the complainant if she called the police, the complainant knew the consequences, while making a circle in his hands, gesturing as if to strangle the complainant.
So there's also felony retaliation.
Yes, Your Honor.
Is this within what you just said now, or is it something else that happened? Because I know it arises out of the same, but was there any more overt action that was done other than spoken word?
Sorry, Your Honor. Let me check the DIMS.
Okay. Mr. Javed, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
Yes, yes, sir.
I'm ordering you as a condition of your bond not to have any contact with this complaining witness. Do you understand?
Yes, sir.
I'm entering in, or it looks like a protective order has already been issued on the 9th of this month. I would get to know it. If you do something to violate this protective order, the state can and will file additional charges as violation of protective order. And I'm telling you, that's one of the worst cases you can pick up. You violate conditions on a no contact order, I can hold you at zero bond, and I will do it in a second to protect every person of Harris County. Do you understand?
Yes, sir.
When I mean no contact, I mean no contact of any kind. Phone calls, text messages, social media, use of another person to relay any information. I'm also ordering you as a condition of your bond not to be in possession of weapons. Do you understand?
Yes, sir.
If you violate these conditions, I will revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. And I'm telling you now, I'm going to make it high. So no contact of any kind.
Your Honor, appears to be just the verbal threats.
Okay. So can you file no contact and no weapons, please?
Yes, Your Honor.
For now, I'm going to have you sign a reset with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign the bond conditions, and then we'll have you wait for your lawyer. Okay? Please.
All right, page 12. Go ahead and sign the
Mr. Dakota, do you have an arraignment?
No, sir.
No? Okay.
coupon.